This morning on NECN, jury selection begins today in Karen Reed's retrial. What we can expect from the courtroom as Judge Cannoni makes last-minute decisions.
More than 200 attorneys in Maine are calling on legal groups to stand up to Trump. Their message to organizations as the president's tariffs are set to roll out tomorrow.
And one person is dead in Bridgeport, Connecticut after a shooting that involved police. What investigators say started the incident. NECN This Morning continues right now. But first, we turn to the Karen Reed case. Jury selection set to begin very shortly, actually right now, as her second murder trial gets underway. Good morning, and thank you so much for joining us. I'm Monica Medea.
And I'm Melody Mendez. So after months and months of court filings, pretrial hearings and motion hearings, jury selection began about 31 minutes ago. This is video from just then of Karen Reed and her legal team walking into the courtroom today, escorted by state police there as they made their way into the courtroom. You can see the barricades on the right and left set up to keep folks away from the courthouse. There is a buffer zone of 200 feet there. She gave a thumbs up as she walked into the courtroom, into Norfolk Superior Court there in Dedham. So let's go now to our Manash Kungwari, who is out there this morning.
Well, today will be the first day of jury selection in the Karen Reed retrial. And one of the differences about this case is how the defense plans to defend Karen Reed. Of course, they believe she is being framed for the death of John O'Keefe. In fact, he was found dead outside of a man by the name of Brian Albert's home back in 2022. During the first trial, the defense pointed the finger at Brian Albert, his nephew Colin Albert, and a man named Brian Higgins. But Judge Beverly Cannoni just yesterday ruling there is not enough evidence to blame Colin Albert. Going on to say, if the defense is to make a case against the other two this time, they need to provide more evidence than what they did the first time. But ultimately, it's the jury that will decide if Karen Reed is guilty, and the process of selecting the 12 to make that decision starts today.
A lot of times people say that we're looking for a fair and impartial juror to be able to put them on the panel to ultimately sit. Neither side is truly looking for a fair and impartial juror. What they're really looking for are jurors that are likely able to agree with their version of the events.
And as you can see, the barriers are in place and the Karen Reed supporters have showed up. We, of course, will be keeping you updated on what happens when jury selection hearing begins at 9. Right now, reporting in Dedham, I'm Manash Kungwari.
All right, now we want to bring you live pictures from the Karen Reed retrial right now. Karen Reed is in court right now. If we can bring up those pictures, you're going to see her standing there without her team of attorneys next to her. That's because, as we understand it, they are in sidebar right now. There's David Yannetti just walking back to the table. You see Elizabeth Little. There is Attorney Alan Jackson, Robert Lessie as well, and there is the prosecutor in the background. So here's what you're seeing. If this looks unfamiliar to you, this setup, it should. This is not the courtroom where the Karen Reed trial took place last time, nor will it be where the Karen Reed trial takes place this time. The retrial is going to happen in the same small courtroom there in the Norfolk Superior Courthouse as we saw the last trial. But right now, they are in the bigger courtroom in that same building. There you see Judge Beverly Cannoni and the court clerk in front of her. The reason they're in this bigger courtroom, Monica, I was actually in the courthouse yesterday and speaking to a lot of folks there, and the court clerk told me that essentially the room that they do the trial in is just not big enough to handle the number of potential jurors that will be coming in and that will be impaneled. So keep in mind the numbers here. They've got 218 jurors that were summoned to report to the courthouse in Dedham. They are estimating about 175 will show up. Now, you're not going to see any of them here right now, because what's happening is those jurors are all being staged across the street in the Registry of Deeds building, and they will be brought over group by group to be questioned.
And it sounds like proceedings are underway, so let's listen in.
You solemnly swear to make true answers to such questions that should be put forth to you by the court, so help you God. Thank you. You can have a seat now, I promise. May I call the case, Your Honor?
Yes.
Your Honor, this is 22-117, the Commonwealth versus Karen Reed.
Counsel.
You want counsel? You want me to say?
Counsel.
Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson on behalf of Karen Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George on behalf of Ms. Reed.
Good morning, Ms. George. Good morning, Ms. Reed. Okay,
Karen Reed, can you please stand? Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to any of them, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
Okay, good morning, jurors. My name is Beverly Cannoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on what you will be asked to do. So, jury service, as you know, is one of the most important duties we have as citizens. We appreciate that you're here, ready, willing, and able to serve if you're called upon to do so, and our system of justice simply does not work without you, so we thank you. This is the case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. So Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and with leaving the scene after causing personal injury or death. I will describe these indictments in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in greater detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while the public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple, and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask you questions, all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you are not selected for jury service on this case, you should not take it personally. Don't think that somehow you're not a fair person, because it's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for another case. In a few minutes, I'll pose a number of questions to you as a group. You have just taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer can read the number from the card. You don't have to get your cards out yet. I'll tell you when it's time to get your cards out. Now, the fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that counsel and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer the question at sidebar. I may have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror in this case. And the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer to any question. We're simply looking for your honest and best answers to the questions. Now I'm going to have the lawyers introduce themselves. We'll start with the Commonwealth, and when the defense introduces themselves, please introduce your client. Mr. Brennan,
Your Honor.
Please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me are two other attorneys I'd like to introduce you to. All the way to my right is attorney Laura McLaughlin. Good morning. And next to me is attorney Adam Lally.
Thank you. Defense counsel, please.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the privilege of representing Ms. Karen Reed, who is to my right.
Good morning, members of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen of the jury. My name is Robert Alessi, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston. I also have an office in Dedham. It is my privilege to represent Karen Reed.
Good morning, members of the jury. My name is Victoria George, and I have the pleasure of representing Ms. Reed.
Good morning, Karen Reed. Thank you for being here.
All right, thank you very much. Folks, I'm going to read a very lengthy witness list to you. It's important that you listen to the names because at some point I'm going to ask you whether you know any of these folks. So when you hear it, please listen to it in those terms. Now, it does not mean that all 150 witnesses are going to be called at trial, but you'll hear their names if they're not called. You may hear their names during trial. So it's important that we know if you know these folks. The list is alphabetical, but it's alphabetical by first name. So Aidan Kearney from Jefferson, Mass. Dr. Aziz Wolf from South Miami, Florida. Alfredo Lopelato from Canton. Allison McCabe, also Canton. Andre Porto from the Massachusetts State Police Crime Lab, Andrew Klain from Bridgewater, Andrew Rentschler, PhD from Pittsburgh, Angela Malvone from Canton, Annie Chung from Canton, Anthony Flamati from the Canton Fire Department, Ashley Bell from Canton, Ashley Valliere from the Massachusetts State Police Crime Lab, Brian Albert from Norwood, Brian Albert Jr. from Boston, Brian Higgins from Sandwich, Brian Loughran from Canton, Brian Wanless, retired Canton Police Department, Bridget Meehan, keeper of the records in Canton, Caitlin Albert from Easton, Charles Ray, a lieutenant with the Canton Police Department, Chief of Police of Canton, Helena Rafferty, Chris Van E., PhD from Novi, Michigan, Christina Hanley from the Massachusetts State Police, Christopher Albert, Canton, Christopher Curran, Canton, Colleen Crawford from the Norfolk County District Attorney's Office in Canton, Colin Albert from Canton, Courtney Proctor from Canton, Kurt Roberts from Canton, Daniel Whitley from the Canton Fire Department, Daniel Wolf, PhD from Penns Park, Pennsylvania, Derek Ellington from Wake Forest, North Carolina, Dr. Marie Russell from Los Angeles, Dr. Elizabeth Loposada from Providence, Elizabeth Proctor from Canton, Eric Hanlon, Canton, Erin Beatty, Canton, Erin O'Keefe, West Bridgewater, Francis Walsh from the Canton Fire Department, Darren Wing from Green Cove Springs, Florida, Gary Fowler from Brockton, Gregory Woodbury from the Canton Fire Department, Gretchen Voss, Boston, Mass., Hannah Knowles from the Massachusetts State Police Crime Lab, Heather Maxon from Walpole, Arabito Hernandez from the Boston Police Department, Holly Price from Mountain View, California, Ian Whiffen from Vienna, Virginia, Dr. Irene Scortibello from the Office of the Chief Medical Examiner in Massachusetts, James Crosby, PhD, from Jacksonville, Florida, Jason Becker from the Canton Fire Department, Jean DeMulis from Canton, Jennifer McCabe, also Canton, Jessica Hyde from Bridgeport, New York, John O'Keefe Sr. from Braintree, Judson Welcher, PhD, from a company called Aperture, LLC, Julie Albert from Canton, Julie Nagel from Canton, Dr. Justin Rice from South Weymouth. There's a juvenile whose initials are KF from Canton, and there's another juvenile whose initials are PF, also from Canton. Caitlin Boudreau from Raynham, Karina Kolakithis from Canton, Katie Camerano, also Canton, Katie McLaughlin from the Canton Fire Department, keeper of the records for Ring from Hawthorne, California, Kerry Curran from Canton, Kerry Roberts, Canton, Kevin Albert, Canton, Kevin O'Hara from the Massachusetts State Police, Lance Mello from the Massachusetts State Police Crime Lab, Laura Sullivan from Pembroke, Laurie Cahill from Worcester, Leslie Pearlstein from Canton, Lieutenant Michael Lank from the Canton Police Department, Louis Jetris from Canton, Lieutenant Brian Tully from the Mass State Police, Lieutenant John Fanning from the Mass State Police, Lieutenant Paul Gallagher from the Canton Police, Maggie Gaffney from Bonita Springs, Florida, Mark Lopolato from Canton, Margaret O'Keefe from Canton, Marietta Sullivan from Pembroke, Mary Souza, Dighton, Matthew Amory from Canton, Matthew DeSogra from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly, Canton Fire Department, Matthew Kelsch, the Federal Bureau of Investigations, Matthew McCabe from Canton, Maureen Harnett from the Mass State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano from Canton, Michael Easter from Los Angeles, California, Michael Trotta, the Canton Public Works Department, Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Wyweek Berschneider from San Marino, California, Nathan Reed from Raynham, Nicholas Bradford from Lorton, Virginia, Nicholas Curran from West Roxbury, Nicholas Kolakithis from Canton, Nicole Albert from Norwood, Norfolk County District Attorney Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barrows from the Dighton Police Department, Patrick Haggerty from Somerset, Paul Makowski from Melrose, Paul O'Keefe from Canton, Rebecca Bison from Canton, Rebecca Treyers from Norfolk, Mass, Dr. Renee Stonebridge from the Office of the Chief Medical Examiner's Office in Boston, Richard Green from St. Pete Beach, Florida, Richard Donatino from Canton, Robert Gilman from Hull, Ryan Nagel from Canton, Sarah Levinson from Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul Giampietro from the Canton Police Department, Sergeant Yuri Buchanan from Massachusetts State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh from Canton, Sophie Herzan from the Mass State Police Crime Lab, Stephanie Devlin from the Mass State Police Crime Lab, Stephen Mullaney from the Canton Police Department, Steve Nelson from the Norfolk DA's office, Steve Bernstein, who is a keeper of the records in Stoughton, Stephen Ridge from the Boston Police Department, Stephen Seraph from the Canton Police Department, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty, Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton, Trooper Connor Key for the Mass State Police, also from the Mass State Police, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Kostowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robery from Canton, William Reed from North Dighton. That's the list of witnesses, folks. So in a while, I'm going to ask you all if you know any of those folks. So as you can imagine, this case is expected to take a while. The lawyers tell me that once we get a jury, which may also take a while, once we get a jury, that it's estimated that the evidence in this case should take 6 to 8 weeks. We do our best to let you know in advance what we anticipate the length of trial will be. When we start the trial, we will go full days so that we can expedite the trial. The dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half days throughout the schedule. So that's the schedule that we intend to keep. Now, it might help you if I give you a preview right now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal principles that govern the trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring her to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, "You accuse me, now you prove it, and prove it beyond a reasonable doubt. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before the jury in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. A juror's job is to find the facts. In determining the facts, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and circumstantial evidence. I'll define those terms in greater detail later, but direct evidence essentially is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, I've used the word inference. An inference is a logical deduction or conclusion that you may, but are not required, to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one which is not too remote in the ordinary course of events. You may not guess. You may not speculate or engage in surmise. When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, obviously, as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of on unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So, for jury selection, it's important to know if any of you might have doubts whether you can accept and follow these legal rules. So I'm going to ask you questions in a few minutes. So if your answer is yes to any of my questions, please raise your hand. Before we begin, though, I understand that sometimes jurors do not fill out the juror questionnaires completely, that sometimes we are in a rush to send them in, or sometimes we don't think that our situation applies to the question that is asked. If the lawyers and I notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us. Also, if you know now that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether as a party in a case, a witness, or a juror, please let us know. So while you're taking out your cards, I will see counsel and Chief Rosen, juror number 79 too, and counsel at sidebar, please.